Good afternoon. My name is Reyna de la Cruz, and I'm a staff attorney at the Texas Children's Commission. I would like to welcome you to our webcast entitled Enhancing the Experience of Parents Involved in Child Welfare Cases. This discussion will focus on the importance of the attorney-client communication, best practices for preparing clients for court appearances, and legal advocacy inside and outside of the courtroom. The Q&A and chat features for this webcast have been disabled. The MCLE number for this course will be provided at the end of the presentation for those watching live. For those watching the webcast replay, please email cctraining@txcourts.gov for MCLE self-report information. I'll now turn it over to Judge Robert Falkenberg, Associate Judge of the Child Protection Court of South Texas, to introduce you to our panel.
Thank you, Renee. Good afternoon, everybody. Welcome to the webinar. I am Judge Robert Falkenberg. I'll be your moderator today for the discussion, and this would be a great time to invite our parent panelists to introduce themselves to you. So, Ms. Reyna, would you please begin?
Yes, Judge. My name is Jacqueline Reyna. I'm a parent with lived experience from Bexar County.
All right, and Ms. Townsend?
Hello, my name is Kameryn Townsend. I am a parent who lived experience with child welfare services in Travis County.
And Ms. Dyar?
Good afternoon, everyone. My name is Cynthia Dyar, and I'm the director of the Texas RioGrande Legal Aid's Family Defense Project. I represented Ms. Jacqueline Reyna.
And Ms. Vanderzanden?
Hi, everyone. My name is Janet Vanderzanden. I am a staff attorney with the Travis County Office of Parental Representation here in Travis County, and I represented Ms. Kameryn Townsend.
Well, welcome all of you, and thank you for participating today. We'll start with Cindy and Janet. Would you please each provide a brief overview of your client's case and any of the biggest obstacles that they had to overcome to achieve reunification? And Cindy, why don't we start with you, and Jacqueline, please.
Thank you, Judge. So Jacqueline had her two children removed in Bexar County. I believe they were 4 and 5 at that time, in June of 2020 for her drug use. Her last positive drug test in the entire case was that same month. Jacqueline's service plan was created in July of 2020, and she had finished all of her services within several months, except for 2 that she was not aware of that were recommendations of a psychological evaluation that she'd never been provided a copy of or otherwise told about. Once she learned of that in the spring of 2021, Jacqueline had requested a new court-appointed attorney. She followed up with court staff, and then I substituted into the case in June of 2021. Ms. Reyna was not granted unsupervised visitation until after mediation in June of 2021, and her children were eventually returned to her in September of 2021. The case was dismissed in December of 2022. Jacqueline's main obstacle in that entire case was poor communication with the department and her attorney, as well as the advocacy by her court-appointed attorney.
Thank you, Cindy. We lost you for just a few minutes, but we'll probably fill in those gaps as we go through the course of the questioning. All right, Janet, could you tell us a little bit about your case with Kameryn, please?
Sure. The Department of Family and Protective Services first got involved with Kameryn and her daughter back in October of 2017, where they filed a petition for non-emergency removal when non-emergency removals were still a thing in Texas. And after an adversary hearing, partly because Kameryn was very, very engaged with the process, but also because her child was placed with a family member, our judge here in Travis County proceeded with a Chapter 264 court-ordered services case instead of a temporary managing conservatorship case, but kept placement of Kameryn's daughter with the family member. Kameryn worked services and was very engaged, but unfortunately had a relapse about June of 2018. And at that point in time, the case became a full temporary managing conservatorship case. Kameryn had a full service plan, including a psychological evaluation and psychiatric evaluations and psychiatric treatment. The primary concerns for her were drug use and her mental health. She did parenting classes. She worked with a parent coach. She had a full array of services. And ultimately, she was granted a monitored return with her child on or about December of 2017. And then the department held on to her case as long as they possibly could until it was finally dismissed in the summer of 2018. So when all was said and done, she worked in a court case for about 2.5 years.
Well, thank you both for the summaries of those cases. And as we go through this conversation, we'll find out more detail and flesh out some more of these issues that the lawyers and their clients were able to overcome in these cases. Let's start out talking about the lawyer-client relationship, because it's obviously a huge aspect of these cases. And one question to think about is, what can a lawyer do to improve their relationship with a client and increase the quality of their representation? We've referred to this as knowing your client and a holistic approach to the representation, or a holistic understanding. So getting into that, I'll start with the parents. It'd be really unique to get their perspective first. So Jacqueline, when were you first appointed a lawyer? Was it before your first court hearing?
I was appointed a court lawyer, assumably before my first court hearing. I was unaware who that lawyer was, and I had no communication with the lawyer even right after my first court hearing.
When did you finally find out that you had one?
At
Or
my
how did
first,
you find out?
I found out I had one through the paperwork that I received for the first hearing without name. I heard his name the first court hearing. I heard his voice. When that court hearing ended, I contacted CPS to see how I could get a hold of him. And then it took me a month or two before I could figure out how to communicate with him, and reached out to him about my case.
Did you understand what the dynamic of that relationship was supposed to be like? Did you understand that there was an attorney who was supposed to represent you in your case and help you through it?
I believe I could say my initial understanding was what I saw on TV and movies. Attorney-client privilege. He was going to reach out. He was going to be an advocate for me, and all my trust needed to be on my lawyer so my kids could come home. And even in the brief conversation I had with him the first time when I found him, his communication with me was, "Oh, I'm so grateful to talk to you. I love parents who engage. Your kids will be home in 6 months. Just everything is going to be fine."
Who reached out to who first? When you finally had the opportunity to connect with your attorney, was it him contacting you and establishing that rapport, or was it you contacting him?
No, no, Judge, it was me. I actually had to Google him, and I tried various emails. I tried phone numbers that didn't work. I reached out to the courts. And then after a month or two, I was finally able to get him on the phone for about a couple of minutes. And that was the gist of the conversation.
Did he explain anything to you at all about the process and how things would work?
No, Judge.
How did that make you feel?
At the time, I was numb to everything, and basically I took it upon myself that I was like, okay, I guess I need to educate myself, because I didn't know the process. I didn't know. I just figured he would be at the court. So I basically educated myself on my own in between court hearings.
When you finally had that first meaningful conversation, or the most meaningful conversation that you had, how far into the case were you already?
The first meaningful conversation I had was with Miss Cindy, and that was almost a year to the beginning of my court case.
So your first attorney never had any type of conversation like that with you?
No, Judge.
Okay. I'm going to jump over to Kameryn real quick, and we'll talk about your experience with that same issue. Did you have an attorney before your first hearing? And if so, did you know, were you aware of it, Kameryn?
Yes, I received an email and a phone call from Janet's office letting me know that she was appointed to me. And she set up a time before court that we can be able to get to know each other and basically, get an understanding of my case while I was there and what the goals were.
And did you have a good understanding before you went into that first hearing and the opportunity to explain your side of the story to Janet?
After meeting with her and explaining everything, yes, there was a good understanding, but prior to, no.
How did she make you feel after you were able to meet with her about your position in the case?
Reassuring me that, that I basically could make out of my case greater than the expected, and also letting me know that she's going to stick beside me through everything. So with that, it made me feel a lot more better.
Was it very helpful to know that you had someone in your corner who reached out to you and contacted you about your case?
Absolutely. It made me feel like someone else cared.
Well, with that, Jacqueline, let's jump back to you and let's talk about, we've heard Kameryn's situation was very different from your first situation. How did things work with Cindy when you were finally connected with her?
When I was finally connected with Miss Cindy, things happened very expeditiously, and quite honestly, in the very first month of her being my counsel, I probably had more breakdowns than I did the first year, because Cindy made me so completely aware of what should have happened and what processes and steps and paperwork that did not exist in my case. So that was very scary to me, to know that the advocacy wasn't there for me. And even when I tried to advocate for myself, I wasn't permitted to. So I had to switch modes when Miss Cindy came on, because I was so intent on advocating for myself that I had to take a step back. But the comfort and the transparent communication that Cindy had, I'm hoping it didn't take too long. I got comfortable very quickly with her because I saw the difference in the advocacy.
What was the comparison to meeting with your first attorney compared to meeting with Cindy?
There is no comparison. As far as I feel, I had a lawyer a year after my case began.
And once you had a chance to meet with Cindy and talk about things, and you felt like you had that representation, did you feel better about what was going to happen in court after that?
Definitely. The first year, I would always try to interject and advocate for myself. When Miss Cindy took over, other than when I was asked a question, I don't think I had to communicate at all, because we already had conversations before. She already knew what my intentions or what I wanted done, and it was always communicated through her in a very professional manner to the courts.
Let me jump to the lawyers. Cindy, we'll start with you. You heard what Jacqueline's experience was, and you know what her experience was with her first attorney, and then you know what you had to do coming into the case. But let's just talk generally, and how often after receiving an appointment do you reach out to your client? How soon do you do that? And I understand you know you're at RioGrande Legal Aid, so things are a little bit different, but what's the process and what's the policy there? And what do you think is appropriate as far as attorneys reaching out to parents in CPS cases?
Sure. And so when I was a court-appointed attorney at the Travis County Office of Parental Representation, as soon as I was appointed, if I could that same day, because these cases move so quickly, I would reach out, if not that day, within 24 hours. That was to introduce myself, to explain when the first hearing was, where the hearing was, and then to set up a longer 2-hour meeting with that client well before the hearing so we could get through what we needed to for that hearing.
Janet?
Yeah, I concur with that. In Travis County, we're fortunate that parents get conditionally appointed counsel as soon as a case is filed. And then it is on them to, and their lawyer to get an affidavit of indigence filed and get that conditionally appointed appointment continued. But as soon as we are made aware that we have been conditionally appointed to a case, my office is contacting the investigator because that's the person who's going to have the contact information for the client. And then as soon as that we receive that contact information, we are immediately trying to establish contact because it may not happen right away. And certainly, parents who have just gone through a removal or who are very intertwined with CPS are bombarded with all kinds of different people calling them and asking them things. And it can be very, very confusing to understand who anybody is or what they want. And so it's really important to establish from the onset that you are their appointed advocate. And it's important that you have the opportunity to meet with them and hear their side of the story. Because at that point in time, nobody is listening to their side of the story. And it's really, really important to establish early on that you're going to be the person that is going to do that for them.
I think that conditional appointment, especially in the arena of a CPS case, is so important in that frame because it gives you the opportunity, as both of you said, to reach out almost immediately after the removal and deal with whatever acute issues are happening that will allow you to be prepared for that first hearing. And that's what we do in the Child Protection Court of South Texas, is the conditional appointment prior to the adversary hearing. And I have found that to be a really good tool to use as well. So what is it, Cindy, that you discuss at that initial meeting? What are the things that you're going over once you sit down or have that phone call or Zoom meeting with your client?
Sure. And so this is assuming before the adversary.
I think Cindy might be, there she is.
She is.
I apologize, everyone. So I have them mark up the affidavit before our 2-hour meeting with any issues or concerns they have or things that are missing. In that 2-hour meeting, I'm explaining the timeline of a TMC case. I'm explaining what's going to happen along the way. I'm explaining what a contested 262 or adversary hearing is, the right to that, what that means. Then we're going over what else is going to happen at the initial hearing. I'm going over placement options, gathering all information I can for those placements. I'm going through their visitation plan. And so I'm doing all of that before the initial hearing, right? So that I can make requests to the court at that hearing, but also so my client in deciding whether to pursue.
Judge, I would add to what Cindy was saying in terms of why that initial meeting happening so soon is so important, is because particularly when you have a conditional appointment and you have some time before you first see the judge, there's a lot of work that an attorney can do for a client in that time period. You can be proposing family placements. You can be vetting family placements. You can be looking into potential services. You can also be looking into different options for visitation so that when you're having these conversations with the various different professionals that are going to be relevant once you get to that hearing, you've already done that legwork. You've already had those conversations, and hopefully you've been able to make some agreements. And if you've not been able to make agreements, then you have teed up by the time that you even get to that initial hearing, what some of those really important requests are going to be made. Certainly getting home studies started as soon as possible is critically important. And so all of that is going to be dependent on the information that you're able to receive from your client. It's also a really important time to be able to explain to the client exactly who all the different players in this case are going to be, who the ad litem is, who the guardian ad litem is, and not only who they are, but what their role is, what role they're going to play and why they're going to be important. And making sure that your client really does understand all of these moving parts to the best of their ability, so that they have a sense of what's going to be not only expected of them, but what they can do to help their kids as much as possible.
Do you find that when you have that initial meeting, you run into the issue of your client looking at you as an extension of the system or somebody who works for the state? And if you find that, how do you deal with it? And how do you develop that relationship with them to show that you're their advocate?
It definitely happens. And before it even comes up, I try to head it off at the pass. especially because I do work for the county. My office is a county office, and so my email address has Travis County at the end. I am in a county building, and so the very first conversation I have, I explain who I am, what my office does, how we are not in any way associated with DFPS, how we do not work for DFPS. I spend a lot of time explaining what attorney-client privilege is and what it covers and what that means and how important it is. And I try to give a lot of reassurances about what my role is and what I can and can't do for them, but also why I am different than everybody else who's involved.
Kameryn, when you met Janet and you had these initial meetings, did you get the sense that she was there for you, or did you feel as if she was just another part of this big system that was invading your life?
I honestly felt like Janet was like a long lost family member that is like came to save the day. When we like after meeting a couple of times, she's just like, look, this is what's going to happen. Listen to me. I'm going to guide you. And she made me feel very, very happy.
Was it the way she communicated with you, or was it the things that she told you? What was it about that made your attorney feel like a long lost family member?
It was the communication, and then everything she said, she backed up. So if she said that we're going to do this at our next court hearing, it happened. If she said that we're going to fight for this to take place, we're going to remove this from services, it happened. So it's like I had no doubt in her. Anything she told me that was going to happen, it made me feel confident that it was actually going to happen.
Cindy, we lost you for a minute, but we're kind of jumping to this idea of developing that relationship with the client. Do you run into that issue, and did you have that issue with Jacqueline, especially after her experience for a year, with getting her to trust you and to feel as if you were there for her, you were her advocate? Yeah, you were her advocate.
Sure, and I'll handle the Jacqueline question first. I think that's a little different because Jacqueline came in search of me at legal aid, and so she sought me out after receiving a referral from TLSC's family helpline. And so I think, though, because of her prior experience, as she talked about a little bit earlier, it did take us a few weeks for her to understand that I wasn't going anywhere and that I was going to advocate on her behalf because of the year she'd had with her court-appointed attorney. But yes, as a court-appointed attorney with Travis County for a decade, I had that experience a lot. And I think for me, it was explaining to my client at the initial meeting exactly what my role was, what everyone else's role was, but really also explaining attorney-client privilege and establishing that trust and relationship from jump. And then I do think when clients see you along the way, taking stances, asking for what they want, and advocating, they can start to understand that as a court-appointed parents attorney, we are there for them and not part of the system.
Jacqueline, we've kind of talked about how your first court-appointed attorney's relationship was with you, but once Cindy came on and she did the things that she's describing, what was that relationship like as you moved forward in the case?
That relationship was like night and day. I can't go to presume other people's relationships, but the fact that Miss Cindy was not Bexar County was a big thing to me, because of by the time Miss Cindy got there, whatever I said to her didn't end up back in court, which with my previous lawyer, the handful of conversations I had with him, I immediately got a very random call from my caseworker not happy with me. So I was actually happier with the fact that she wasn't what I falsely consider like part of the system, the Bexar County system, because my experience with it just seemed like a whole bunch of beds and they've known each other for years and things like that. So for me, the comfort happened in the beginning because she wasn't quote unquote part of that particular county system. But the full commitment to Miss Cindy was because every time we had a hearing or we had any type of communication via email or anything, she was the one advocating I didn't have to say anything, and she can anticipate the question. She would already have the email sent out. She would always CC. There was so transparent communication that I didn't have that feeling in my gut like I'm being talked about behind my back.
So the issue of trust is something that you really felt Cindy established early on.
Very much so, yes, Judge.
And do you feel like Cindy was able to find the best way for the two of you to communicate? Everybody has their own way of communicating, and everybody has a different type of body language and ways to communicate that make you feel more comfortable. Do you feel like Cindy was able to use those sorts of tools to help you two better communicate?
I believe that Miss Cindy's manner and communication is perfect for me, because I am not necessarily somebody who wants to be like sunshine and roses. I want to know the worst case scenario so I can prepare myself for it. And then, okay, this is what we're building off of. I understand that's not necessarily the best for other people, especially in the circumstances that we were in. Every possible emotion is flooding, and Miss Cindy saw me have every possible emotion, but because of how she presented things to me and communicated with me, I could have my little breakdown, but then I was like, okay, I didn't wallow in it, because prior to her taking my case, I had a year of being in my own head, of contemplating every worst case scenario in my own head, and somebody not there to talk me off the ledge. And that's what she did. She was always a straight shooter. Her bedside manner, like I said, worked for me, because it was no sugarcoating anything. Like, this is how it is. These are the facts. Like, always there if I needed her, and I'm sure she listened to me more times than she had time to do when I was venting. But the reality is, she could always say, well, this is law. This is the law. And like, you have to remove emotions. That was the hardest thing, I'm sure, for any parent, including myself, is having to separate yourself from everything that's going on and focusing on the law of it. And that's why you need an advocacy lawyer, because you're dealing with so many emotions. It's hard to separate yourself with the law and the emotions. And she's amazing at being able to do that, in my opinion.
Kameryn, you had a similar experience with Janet. You had some tough meetings where Janet made it clear to you what it was going to take for you to get to reunification, correct?
Yes.
And how did that make you feel about your relationship with Janet and the level of trust that the two of you had?
Sometimes during those tough meetings, I would feel like, maybe she's out to get me, but in all, I had to realize that I was out to get myself, and she was only there to help me. So if I didn't accept her recommendations, her guidance, then I definitely would have lost my kid. So it was, a little bit of big sister, little sister rivalry a little bit. But once she said it, it's like, okay, I'm going to see what you say, and let's go ahead and go with it. And all in all, it worked out.
After you developed that dynamic in your relationship, did you feel that you had the ease of reaching out to her when you had questions, or if you have concerns? Did you feel like there was an open door to ask those questions and get that help?
Oh yeah. If a question popped up in my head at like 3 o'clock in the morning, I'll send her a text message or email. Even if she didn't respond right then and there, I knew within the next day or so, she's going to be like, okay, let's go ahead and address this concern that you had at 3 o'clock in the morning. Anyway, let's talk about what was going on at that time, and let's figure it out. And it definitely helped.
Janet, so maybe you get these 3 o'clock in the morning texts, and you're getting this information requests from Kameryn. So you've had your initial hearing, you've developed this relationship. What steps are you taking at that point to maintain that attorney-client relationship as this case goes on? It can be frustrating for the parents. They're doing all these services. Sometimes they probably feel like they have a lot of people who are taking shots at them as opposed to supporting them. What do you do in that situation to keep your client going and to make sure they feel they have zealous representation?
So the very first thing I tell clients is you can text me at 3 o'clock in the morning, but I'm not going to text you back at 3 o'clock in the morning, because I do think it's really important for our lawyers to have some boundaries for what that reasonable expectation is. And so I think that you do that early and you do that often, or you're not going to survive as a practitioner in this area for very long. But I also think it's really, really important to establish that level of trust of you need to be responsive. And so what you might consider to be an emergency or something that a client should be concerned about may be very different than what they consider to be an emergency or something that they're very concerned about. And their concerns are valid because these are their children. This is their life, and this is the most important thing in their life. And so validating that for a parent is going to go a long way in not only establishing trust for them, but also motivate them to do what they need to do in order to achieve their goal. And that's just a critical component of it. I always say that as a practitioner, as an attorney representing parents, you've got to meet your client where they're at. And that's going to be very, very different for different parent clients. There are some that are going to be able to be very rational and very logical, and all that they're going to need is the blueprint for what they need to do, the X, Y, and Z to get their children back, and they can be off to the races. And there's going to be a lot of clients who are not going to need that. And it's going to be a constant re-explanation of why is DFPS even involved in your life in the first place? And what are the reasons that they're here? And what are the steps that you have to take in order to get them to a point, or to get a judge to a point where they feel comfortable returning your kids to your care? And so we like to take a holistic approach to representation, and it's not just a service plan. It's not just checking off boxes of what a court has ordered you to do, but it's about making the fundamental changes in your life that are going to enable you to be in a position that's very, very different than the one that you were in when your children were initially removed. So it's about having that back and forth with a client about validating what they care about, validating what their concerns are. And they may have very legitimate concerns about, for example, the way that a caseworker talks to them. And so I very deliberately and carefully explain about the things that we have control over and the things that we don't have control over. And who your caseworker is not going to be one of them. And the way that your caseworker talks to you is not going to be something that you have control over, but you do have control over how you respond and how you talk back to that caseworker. So a lot of this is about empowering and enabling the client to take back some of that control and moving forward with their goals.
Cindy, in this landscape of trust and client relationships, and in the context of a CPS case, which, as Jacqueline and Kameryn both have pointed out, it's very emotional. How do you build trust and maintain trust when your client thinks it's your fault that they haven't been reunified with their child yet?
Well, I think the first thing I do is evaluate whether it is my fault, right? I think that doing this work a long time, we can become super confident that we know what we're doing in every case. And I think step one is checking in with myself, looking through the file, making sure, okay, is there anything else I can do as the lawyer based on the current circumstances or set of facts? If there's not, right, it's really drawing back on that initial meeting with the client when I teed up everything on the case. And after every hearing, we've talked about what else needs to be done to go to the next step, and letting clients understand these are the 3 things you need to do. These are the 2 things you need to do. This is the timeline you need to do it on. When you do those things, I will file this motion, right? But it's continuing to check in on those clients well after that first hearing, having monthly meetings, having contact so that there aren't any surprises when their kids aren't returned, if it's something that needs to be done or addressed on that case. And so I think consistent communication, following through with what I have promised to do, with the motions I promised to file, with the advocacy I've promised to them, and then just ensuring that we are on the same page about how to get their children home. And so I think those conversations with clients can be really, really tough, but I think we have to have them along the way.
Well, that'll walk us right into the next section that we're going to discuss, which is preparing your client for court and making sure they know what to expect when they walk into the adversary, the status, the initial permanency hearing, the permanency hearing before final order, or even trial. So I'll start with you, Kameryn. Before your first court hearing, did Janet go over the specific documents with you, such as the petition or the removal affidavit? Did she go over them with you, or did you do that at the courthouse? Did you do it before? How did that work out for you in your case?
I want to say me and Janet scheduled a in-office meeting with myself, her, and another colleague in her office to go over the court documents and just lay out how court will look for us, and just a few practice speeches and a few court protocols and how for me to handle myself in the courtroom as well, since this was going to be like a very hard scenario with having people discuss my case, things that that I've done, you know, hold my parenting to a certain standard, things like that. So it was more like a preparing thing before court, but it definitely was a meeting prior to.
Did you feel at that meeting that you were being hit with a bunch of information that you did not understand at all? Or did you feel that it was broken down for you in a way that you got a better grasp than you had before that meeting?
I was overwhelmed with a lot of the information. It took me about maybe 1 or 2 court hearings just to understand the verbiage and vocabulary for certain things and the procedure and the steps. But over time, it became more, you know, common to me and relatable. But in the beginning, it was very overwhelming.
As a parent with lived experience, do you think that there's any other way for a parent to get used to the CPS case, get used to the things that you're going to hear, the things that the parties and the lawyers are talking about, you know, considering the busy schedules of the parents involved, the attorneys involved? Is there a better way, or do you think that it's just something that you have to get into and learn how to deal with?
To be honest, I don't think a parent will ever get used to having to deal with something that takes away their children or question their parenting. So it's only a living experience. You can't really answer that question unless if you're actually wearing those shoes at that time. So I can't say, oh, it's going to be okay or do this XYZ, because every parent is different. I know from my personal experience, it gave me anxiety during the case, and I still suffer from anxiety after it. So it's just all about, you know, your representation and really your support on how you get through it.
Jacqueline, did you feel once Cindy came on your case that you understood what was going to happen at your hearings and that you were supported in those hearings?
Yes, very clearly, very confidently, I felt supported.
And was that because you understood what was going to happen? Did y'all practice questions? Did she explain some of the procedure? Did she tell you how to act? What sorts of tools did you all use to get you ready to go into court?
All of the above. We had times where we communicated, with times where she would say, go read this over, write down any questions. We're going to meet back either later today or tomorrow. The difference between Ms. Kameryn's and mine for presentation wise is my case was during COVID. So as bad as it sounds, one of the benefits of COVID is I can watch myself on the screen. So I know how to, like, oh, my face is doing this, or oh, I need to do this. And I was able during court hearings to communicate via text to my lawyer, which I know wouldn't have happened in a live case. There's other notes and things that they do. So whether it was my benefit or my demise, I think my circumstances worked better for me, as bad as it was during COVID and being online. And I wasn't actually in a physical room with people staring at me or people asking or people doing certain things that would have triggered me.
I know we could probably talk all day about the advantages and disadvantages of remote proceedings that we all received a crash course in 2020. But Cindy, you coming into this case with a client who has had minimal representation, is kind of spurned at the whole system, and you've got to do it all remotely. How did you address these things that we're talking about in that realm of COVID and remote proceedings?
Yeah, and I think the first thing is that is difficult, right? When you're going to court only on Zoom, you haven't met anyone on that case in person. That takes away the personal element of that. And so I think for Jacqueline on that, knowing we'd be on Zoom for the rest of her case, I spent a lot of time with her before the court hearing because I was not able to lean over and tell her certain things. We had to change how we would communicate during those hearings. And so I think the first thing is just fully preparing her for what could happen at the hearing with multiple contingency plans in place, since we couldn't always communicate in the moment.
Did you all, getting into the specifics of doing things in the moment, now we're used to it. Now we've had these opportunities to, for almost 4 years, use remote proceedings. Did you adjust rather quickly, or did you find it was awkward? How in Jacqueline's specific case, how long did it take y'all to find your speed there?
Sure. I mean, I think overall we adjusted pretty quickly to Zoom proceedings. Our county went into Zoom proceedings the first week after spring break in March of 2020. So by the time I had Jacqueline's case, we'd been in that for 3 or 4 months. I'm sorry, we had been that up for over a year. Jacqueline's issue was that in her county, proceedings were occurring via phone for much of the first year of that case, and that was incredibly difficult for her. So when it switched over to Zoom, there were some benefits, as in she could see people, she could see the others, she could see the judge and understand a little bit more about what was going on. And so again, a lot of it for us was just making sure that she felt fully prepared, since she could not sit next to me at those hearings. Also for her case, we always made sure that we had everything ready to go with those contingency plans.
Kameryn, going into the initial aspect of your case, did Janet and you talk about what would happen if, or provided that the state was awarded custody of your children? Did y'all talk about those specifics? And what did you understand going into your adversary hearing could be the result?
We talked a little bit about them taking full custody of my daughter during the case, but our main focus was we weren't going to get there. Janet's main goal was we're not going to get there. We're not going to get to that point. She did let me know what it would look like as far as my rights being removed and moving forward, but I really didn't want to even have that a memory or imprint in my mind, because it was one of the main focuses that I was going to get my child home. But it was talked about.
And I think during that time that, Kameryn is speaking of, we were in a position where we had to have a really honest and real talk about what was going to happen at the hearing. And it was based on certainly my experience in doing this area of law and of the particular judge that we were in front of and the facts that we had. And she had a very serious and very recent relapse. And there was only going to be one outcome to that hearing, which was that the judge was going to grant temporary managing conservatorship to the department. So it was really, really important to prepare her for that hearing as to what the result of it was going to be, and have her be focused on how to move forward from that, about what that meant legally, what that meant rationally, and what that meant that her job now was in order to get to her goal, which was eventually her daughter returning home. So even if her daughter wasn't coming home that day, we had to stay focused on what the steps that she had to take to make sure that eventually she could come home.
I think anyone who's ever done any defense work, and especially in this arena, understands that sometimes you're just met with that case that all the odds are stacked against your client. And when you've just met this person, Janet, what tools do you use? You're trying to build trust. You're trying to make sure they know that you're not an extension of the system, that you have their back. What tools do you use in that situation to explain, or did you with Kameryn to explain, look, we've really got to face the truth here without making them feel as if you're just completely taking the other side. What do you do, and how do you handle that in your cases?
I would say that this is a really good example of why attorneys in this field need to be trauma informed and need to understand what those issues are. Kameryn in particular was a child who had been in care herself. And so she had not only experienced the system as a parent, but had experienced it as a child. And so she had very complex trauma surrounding what her prior experience had been. And that definitely added an additional layer of difficulty in her being able to process some of the huge emotions that came with the situation that she was in. And so for us, it was really making that time to make sure that she understood step by step. And sometimes that meant that we had the same conversation 3 or 4 times. Sometimes that meant that we had that same conversation in multiple different ways. Sometimes that meant that we started a conversation and then had to take a break and then had to come back to it. But again, it all comes back to meeting the client where they're at and what their own life experiences are doing to shape the way that they process and understand information. There were some times during the course of Kameryn's case that we got her therapist involved because she had an incredibly good relationship and a very trusting relationship with her therapist. And we would pull her in at times that we needed her as well. So it was really understanding how she processed information to know what approach I had to take, whether that be with something very rudimentary like, this is what happens at an initial permanency hearing, and this is what everybody's going to say, or this is what we need to do in order to get ready for the motion to change placement hearing that you want to have. And so depending on what those different things were would depend on how we approached it. So it's really getting to know your client, getting to know their history, getting to know who they are as a person. And I would also certainly make a plug for communicating with your client service providers, because especially if they're working with a therapist, that therapist is going to have potentially a lot of insights into things that you can be doing that's going to best help this client. So these cases don't happen on an island. You've got to be really dialed into everything that's going on, and everybody is working with your client in order to really develop a plan for what's going to work best for them as an individual.
Kameryn, how did you and Janet handle the situation that might arise where you hear something in court that you don't agree with, that you feel is embarrassing for you or damaging to you? Did y'all talk about how you should react in court? Did you talk about how you should take that information?
Janet had this thing called nudge me or write it. So if I didn't like it, I would nudge her. If I felt like I was going to have an outburst, I was a mile a minute writing it. My face tells signs. So my biggest problem was when someone would say something that, again, attacked my character as a parent, I would get very upset. And I had a bad history of, I didn't care where I was. I was going to swear in the courtroom. I was going to swear in the meeting. I would swear on the phone, emails, wherever. I did not care. But in order for me to show that I'm not this aggressive, outraged, irrational parent, I had to calm down and show different, ways to handle myself in those scenarios. And so it was either a little nudge like, hey, I don't like that, or I'm writing it down, and that helped a lot. So that way that Janet could see like, hey, some of these things that they're addressing as my client is sitting here isn't facts. There's been times where Janet stood up and say, hey, can we not say that? Because we've already proven that this is not true from XYZ, or last court hearing. We've shown proof that this is not a part of an importance to this case. So it helps.
What was your experience with that, Jacqueline? You and Cindy, you were in COVID court, so everything was remote. And you said earlier that you could see yourself. So did y'all talk about how to prepare for that kind of information as you went forward in your case?
I assumed she prepped me how she would prep any of her other clients. It is a little different on Zoom because depending on the judge, you have to raise your hand and get unmuted. Sometimes they allow you to unmute. Obviously, that's told you don't unmute yourself unless you're asked a question. And like I said before, we communicated through cell phone, not in the chats or anything like that. And quite honestly, basically, I went into courts trying to be like robot because, like, similar to Kameryn, like I do not have a poker face, and I'm not in a position anymore to get Botox before court hearings. So I knew I had to practice in front of a mirror. I knew I had to keep my face as stoic as possible. One of the amazing signs I learned and got from my lawyer was you can tell a lot by her eye contact. When she hears something, depending on how her eyes look. And honestly, the only concern I had to focus on is not to smirk, because before I could even text it, I could see it in her eyes, and less than like 30 seconds later, when she had the opportunity to talk, it would be said. So in the beginning, maybe I thought I had text her, but honestly, it was like she already knew. So.
Well, let me flip it to the attorneys. Cindy, how do you prepare your clients for the initial hearing, for an adversary, if it's contested, in dealing with this stuff? What are the things that you focus on and that you think are important for clients to hear?
I think the first thing, obviously, is defining what we're asking for or what our case is about if it's an adversary hearing, and then explaining all the players, what everyone's roles are, what is likely to come out. If it's a hearing involving evidence at all, then I am prepping that client probably 2 to 3 times for a contested 262. We're running through directs. I'm gathering additional information to add in questioning, and typically then I will have one of my coworkers cross-examine the client. So that they are fully versed. My goal with hearing prep is so they know what to expect, but also to take away that anxiety. I can't take it all away, but it is to do as much as I possibly can to prepare the client so they're not hearing everything for the first time in that courtroom. And also so they're not letting all the feelings override what is going on in that moment. And so I firmly and truly and wholeheartedly believe in preparing your client as much as possible for any court hearing. I also think making sure that any of their requests we've talked about in advance, talked about the realities of what those requests are, rank those requests, and again, go in together as that team with a goal for that hearing. But again, I will always circle back around to preparation.
Well, and on the other side of that, Janet, you've had your hearing, some things happened. What sort of briefing, debriefing, follow-ups do you have with your clients?
Well, certainly when we're in person, if the client wants to talk about the hearing immediately afterwards, as long as I'm available and not walking into another hearing, we do it right then and there, because that's when things are the most fresh. That's when there's going to be the most questions. That's going to be when we can get to the heart of things. There are certainly times, though, that especially if there were things that have been said that either, the client feels weren't true or were unfair, they may need a minute. They may need to walk off. And so if that is the case, I would much rather them walk off than have to engage in a heated discussion where there's going to be child advocates or a caseworker or anyone else in the hallway of the courtroom that might see that. And so if that is the case, then we're following up either later that day or the next day with a phone call, just to make sure that the client completely understands what happened. And more importantly, if there were any orders that were made, especially if there are any orders that were made that are different than what the prior orders are. My office always follows up after a hearing and sends the client a physical copy, either by email or by mail, whichever they prefer, of the actual court order, so they can see in black and white the findings that the court made and the orders that they have, so that there are no surprises later on down the road as to not only what they're required to do in terms of services, but what their visitation looks like. I don't like any of my clients to have any surprises. If we get to the end of this and they tell me that they didn't know about something, then I've done something wrong. And so it's really, really, really important to make sure that a client is informed of everything at every step of the way.
Well, and if you practice law long enough, you always run into the situation where your client is telling you about somebody else's case and trying to compare their case to that and questioning your decisions, strategy, expertise based on that information, or they've just been misinformed about something particular to their case or particular to the law. Janet, how do you address those issues with your client?
I let them tell me exactly what it is that they've been told or that they think is true or questions that they have, and I validate those. And I may say, you know, okay, let's talk about what you know about that person's case. And usually it comes out pretty quickly that they only have a very small amount of details about what that person's situation has been. And then we sometimes then compare it to their situation and show how that situation is different. And then I remind them about how long I've been doing this and in what capacity I've been doing this, and not in a way of, you know, you've got to believe me, I know all of this better than you do. And I always remind them that they are the ones that know their child the best. They are the expert on their child, but I'm the expert about what the law says and about what we can and can't do. And so we have to be a team here, and you get to be the expert about some things and I get to be the expert about some other things. And so if we get to that point where there's a lot of questions about, you know, whether or not what I'm saying is true, again, I've done something wrong, because then that means that I haven't established that base level of trust, and we need to go back and revisit that.
Cindy, when you were representing Jacqueline, was there ever a particular player in the case, whether it might have been a caseworker or another attorney, where Jacqueline had a problem with that person and you kind of had to help her see past that? Did you run into that at all? And if not in her case, in another case, and how do you deal with that?
So in Jacqueline's case, I actually shared her concerns about the people that she had problems with based on my own. So I will talk about that with respect to other clients. Yes, I think that there's always going to be tension. This is litigation, right? And this is so serious in the litigation that it is. There's always going to be tension among everyone on the case at some point. And so I think with other clients, when they have issues with the caseworker, with the attorney ad litem, with CASA, part of it is taking the client aside and figuring out what exactly is going on to see if there's something that I can address, to see if there's something I can smooth over, or if it's a valid, tangible thing that I share the concern with that I can address on the client's behalf, to kind of remove that stress from my client and handle that myself. And so I think part of it is realizing, I know a lot of places talk about this as a team approach, right? And we're all on the same team. I don't look at it that way. I try to be as professional as possible and have my clients do the same, but this is active litigation where there are opposite opinions and opposite sides. And so it's respecting that in a professional way, that I understand everyone's trying to do their jobs, but my client might have valid concerns that I can assist with.
You're talking about active representation, and that's our next topic here as we move along. This type of litigation, as you said, and you both have pointed out, and your clients have pointed out, it is very serious. It involves your rights to your children, which is, the Supreme Court has ruled that's a constitutional right. It's an inalienable right that we have, and it's so serious that if your rights to your children are threatened, you get representation appointed to you if you can't afford it. So it obviously is something that the justice system takes very seriously, and to help a parent navigate all the pitfalls and all the potential issues that can come their way in a CPS case, it takes an attorney who really is dedicated to that active representation. So I want to talk to the parents a little bit about what that was like. So Jacqueline, I'll start with you. Did you know what a jury trial was? Did you and Cindy ever talk about what it would be like if you went in front of a jury on your case?
She went over the prospects of doing it when that opportunity presented itself, of whether I wanted to go to trial, whether I wanted to just try to mediate without trial. at that point in time, and after finding out certain information, or rather her finding out certain information related to me, I was pretty gung-ho. I was like, no, I want a trial. I want them to see what they did. So we did get into that again. In my circumstances, I was in COVID. So that trial, that jury trial would have looked different or non-existent in my particular case.
Were you at all intimidated by the idea of going on trial in front of a jury of your peers?
Had I had my first lawyer, definitely. Having Cindy, weirdly, I was confident. Knowing the alternatives, I was determined to do every possible thing. If it was God's will that I lose my children, I wanted them to know that I did every possible thing to get them home.
And did you understand the difference between a judge hearing your case and a jury hearing your case? If it had come to that, did you know what those two different options meant for you?
I don't believe specifically I knew the individualities of it, the peers versus the judge. My focus, when Miss Cindy explained everything to me and that I was like a dog with a bone, is the understanding that if I lost custody or if I lost my rights as a parent, when she told me that my children's birth certificates would be changed and that my name would be removed, there was nothing after that. That was my focus. Like, I'm not having me erased from my children if they got adopted out. And anything, I didn't care what level, whether court, whether judge, like my focus was like, you're not erasing me from my children.
Those powerful words. Kameryn, how do you feel about that same thing, that same topic?
It was a hard no for me. It wasn't going to happen. No. Janet's looking at the camera now because she knows what I really want to say, but I can't say. But it was a hard no for me. I just couldn't. No, I couldn't think. No, I just
So
can't.
if you had been faced with the idea of going in front of a jury, you were, yes, let's do it. I'm not going to be intimidated by anything.
Beginning of my case, I bet it would have been very intimidated because I wasn't in a predicament for me to win against a trial. Over time, towards the end, as my confidence got stronger, as I began my road to sobriety and everything, without a doubt, sign up 12 people, 24, you can keep going. I wasn't going to lose. I wasn't going to lose.
You obviously did, both of you did a lot of hard work in your cases to get to where you are. And everybody who's been involved in a CPS case and has seen a successful reunification understands this parent worked their tail off, okay? But that empowerment that you have, do you also attribute that, Kameryn, to your relationship with Janet and her work on the case?
Absolutely. Absolutely. I don't think that my confidence or my voice would have been heard if I didn't have Janet in my corner. I don't think that I would have been able to stand up to my family, stand up to CPS, CASA, the attorney ad litem. I don't think that I would have been able to stand up to any of them. I felt intimidated by everyone. But as soon as Janet joined the chat, joined the group chat, as they say, it was just like, okay, you know what? I have my backup here. Like, Superman's here. You can't tell me anything. So most definitely, like, without her, they would have hung me out to dry. With her, they couldn't face us.
Words every lawyer loves to hear. Let's talk a little bit about, you have these hearings. We've talked about the representation. There's also a lot of meetings that happen in a CPS case. Now a lot of them happen virtually. Prior to 4 years ago, there was a lot of in-person. Did you and Janet talk about these meetings? Did you go to these meetings together, and did you prepare for them?
Oh yeah, we went to every last meeting that they had. We prepared for them. We talked about them. I've even like reenacted them in some cases when I were like super upset. But yeah, every last meeting that had anything to do with my progress, services, or even getting my daughter back, we were in attendance. If I wasn't able to attend due to transportation, Janet did go in my place and absolutely have me on the phone or let me know. Or I even had a close teacher from middle school that used to go to a lot of my appointments for me. So,
Jacqueline, I want to ask you that same question. How did you feel going into these meetings with Cindy versus how it felt when you didn't have effective representation?
In the beginning, the first and only meeting that I recall was the family care plan meeting. I don't have, my lawyer wasn't at that. It was telephonic, and basically I was of the opinion that whatever you tell me to do, jump through fire, I'll do it. And I advocated for myself, asked if I could get services done through the VA, which is where I get my healthcare, and that got approved. They presented it to the judge, and that was the first meeting. Fast forward, so when Miss Cindy got on and she can clarify it more, my recollection was only mediation, and we did prepare for that. We did. She prepped me for that, but basically when she got into it and she saw the players and the communication, she basically took over, because I think that was her first sight of seeing like, okay, what I was saying like matched up with the players involved. So,
Cindy, how important do you think the strategy and the appearance and the participation in the meetings is? Do you think it's just as important as going to court? Less important? How do you handle that in your cases?
Yes, I mean, I think it's equally as important. Obviously, if I had to pick between a facilitated meeting and attending a court hearing, I would say a court hearing, right? But I think those meetings are equally. There's so much, and I do not understand why clients are sent to those on their own without their lawyer, right? You have everyone on a case there outside of typically the CPS attorney. Everyone else is there. Decisions are being made. In an FGC, you're discussing why those kids came into care, what's going on with them medically and at school, what visitation is like, what services the parents have done, what the goals are for the case, what the primary and concurrent plans are. I mean, the entire case is being addressed in those meetings. And I think it's very odd that attorneys do not attend those. And so I know many counties, there's not even a request for the attorney's schedule. In the county I come from, we are included in that, and we can offer our schedules so that we can attend. I think it's incredibly important also because there's a lot you can get done at those meetings outside of going through the case. I've gotten resolution in those meetings to so many things, issues with placement, visitation. You typically have family supports there that you can draw into the case to assist with placement or visitation. So yes, I firmly believe permanency conferences and family group conferences are especially important for attorneys to attend. I also think it's important, if those meetings are not happening as they should per DFPS policy, that the attorney request those be set to ensure that the parent is having those held throughout the case.
Janet, you were nodding your head while Cindy was talking about the importance of those meetings. What's your take on that?
Yeah, I agree with everything that Cindy said. The real hard work in these cases for both the parent and the attorney happens in between the hearings. If you're an attorney and you're waiting until the court report gets filed to have any idea of what's going on in the case, then you're not doing your job. You're providing zero advocacy for the client. I also think that a lot of times parent attorneys take a very defensive posture in these cases. They wait for things to happen. They wait for problems to to happen. They wait for the caseworker to recommend that visitation change or that a level of supervision goes down instead of taking a proactive approach. Attorneys need to be involved at the very, very beginning, and that means attending that family strength and needs assessment. That means reviewing the family plan of service before it becomes an order of the court, negotiating any changes that might need to be made to it, and then bringing that to the attention of the judge if there needs to be any kind of modification or change to that. Simply accepting what the department files and says this is how things are going to be doesn't have to be the case. And if you're not staying on top of that and you're not advocating for what your client actually needs, they could end up with a family plan of service that isn't actually addressing the reasons why their child came into care, or is not addressing the things that they need to do to be able to demonstrate that they can provide a safe, stable environment for their child. And so that can't be on the parent. They are navigating this without the full knowledge of what all of these things mean legally, what they can and can't do. And your job as their counsel is to make sure that it's happening in the way that it needs to happen, but also if it's not, that you're doing something about it. So it really is about taking a proactive approach to these cases, because not only is that going to make things move faster, but that is going to empower the client to be able to understand how to get out of this situation.
Well, I agree with you both on the issue of the meetings, and especially the family group conference, because it's at the outset of the case. In a lot of counties, courts can allow parties to appear remotely, and they often do. We learned how much time and money remote proceedings can save everybody, and how they facilitate the opportunity for parents to not have to take a full day off work and not have to worry about transportation if they live in an area where they can't get transportation. But what we've also learned is that it kind of creates some disconnect. It's not always the best way to handle certain things. And so in Child Protection Court of South Texas, we had some meetings with several of the people involved in our court, and we determined that either the adversary or the family group conference need to be in person, because people need to meet each other. They need to be handshake, eye to eye, understanding how serious this case is. And really, it's the parents that need it the most. So I have orders that if there's a family group conference, it's going to occur in person unless you have permission from the court to appear remotely. And if there's an adversary hearing in person, we don't do that. And we have found over the course of the last 10 months that that's a very effective tool. So I agree with you all that you can resolve a lot in a family group conference, and lawyers, I firmly believe, in fact, I've ordered it, that they need to be there. Kameryn, did you ever have the opportunity to go over your family service plan with Janet and understand all the aspects of it before you signed it and before you agreed to it?
Yes, every last one.
And did you understand that once you agreed to it and once you signed it, it would go in front of the judge and become an order that you had to follow?
Yes.
Was that scary for you?
Not too much, because it was just basically me doing what I normally was doing outside of having it ordered by the judge, which is the family-based services of therapy, parent coach, psych evaluations, drug tests, things like that. So even though it wasn't ordered already, I've already been doing such. So it's like, I felt like, okay, now someone's actually like monitoring it and recognizing it. Let's go ahead and make sure I stay on the right path.
Moving forward from that point where you go over the family plan of service, it's reviewed, it's ordered by the court. After that, did you and Janet, did she send you documents and reports, and did she keep you up to speed with what was going on in your case from a paperwork standpoint?
Yes. I would get like an email every time something changed to update what I had on file.
Did you understand the orders that you were under in your case? Did you understand what you had to comply with?
Yes.
Jacqueline, what about you? After Cindy's involvement and you were moving forward, even though you were in COVID, did you have that same sort of communication with orders and reports and things like that?
Once Miss Cindy came on, yes, my family care plan, everything, like I said, I did it. I telephonically participated on my own. I was aware I had to complete everything in order to get my children back. I signed the documentation actually at my first visitation with my children. And at that point in time, I didn't have my lawyer. I had the liaison who was with my kids, brought the paper, the CPS told her to give it to us and to sign it. I had a copy of that. I would check it off. On my side, I went through every block, and upon completion of it, I would email it to my caseworker. My particular plan, I paid out of pocket because whatever I was informed that the department was supposed to pay for it, but it never came to fruition. So I paid everything out of pocket, would email her everything upon completion, as well as CC my lawyer. When Ms. Dyar came on up into that year in the hearing and the courts, I was in compliance. And then at like month 9 or 10, all of a sudden I wasn't out of compliance. When Cindy came on, that's when I learned the differences in terminology. I mean, I understood law terminology is like Greek, rather Latin. The term suggestion means you have to. I did not know that. So when I did like the psych evaluations and things like that, and it is the recommendation or as a suggestion, I didn't know that was a requirement. So like having to do domestic violence classes or having to do another psych eval, that's all of a sudden a year into it, what got me out of compliance, because nobody told me until Cindy got on my case that that word means you have to do it.
Let's talk about that a little bit. You used the word Cindy got on my case. Not only did she get on your case as your representation, but she was on your case about making sure you did things, correct?
Yes.
How did you feel about that?
In the beginning, like obviously like the first couple weeks, you are defensive, but I would have preferred that than anything else, because in the beginning, before she actually was able to read into the case and everything like that, she's taking me at face value. But like Ms. Janet said, she's got years of experience in this. And I'm not ignorant or naive to the fact that I'm sure people leave out information to not look bad. I will provide you all the information, truth to a fault, but she has to evaluate me, assuming that I'm holding something back. So like when she talked to me like, well, why are you still drinking if you're not doing this? My ignorance is like, that's not illegal. I'm in trouble for legal stuff. No, nobody told me not to do that. I'm an adult. I should know better. Okay, stop doing that. Care plan. Why didn't you have the second, or why didn't you do this second eval? I'm like, I have no idea what you're talking about. That would sound like somebody's being false. But I did not have any clue what she was talking about, domestic violence classes or a second eval and things like that. So it was like, it was a little bit of exchange, but more so because Cindy just wanted to know all the facts. And that was the only separation, a temporary separation, because I was like, I got more emotional, like, I'm not lying. But I understand in hindsight, like, you have to take it with a grain of salt because people are trying to figure each other out.
Kameryn, you had some of those same types of meetings with Janet during your case, correct? Your progress and what you needed to do differently in the case.
We had a yelling match on one instance, but then it was just like, look, I'm being honest with you, like the paperwork doesn't like it. And so it was just a realization like, okay, you got me. Like, I can't lie anymore. I can't, like, you're actually here to help me. Let's go ahead and figure it out. But when everything hit the fan, it was really like, yeah, It was a good conversation, to be honest, but.
Janet, I feel like, I'm sorry, Kameryn, I didn't mean to interrupt you.
Oh, no, I was saying Janet, she can back me up for that. I've had a few moments where I fell on my face and she's had to just like come and like, you know, bring me back to shore.
Well, I'm of the personal opinion, and I had this experience as a practicing attorney, that when you have that moment with your client, when they realize how much you're fighting for them, that you're willing to get in their face and call them to the carpet because you want them to be successful, and that client kind of hits the bottom for a little bit. Janet, how do you feel about the resiliency of parents in these types of cases? And what did Kameryn show you that she was going to come back and she was going to get this done when you called her out?
Well, first and foremost, she was honest about it. And, you know, what Kameryn's talking about was a pretty serious relapse that she had. And there were some other circumstances that she hadn't been totally honest with me about. And it was challenging for her, and it almost derailed her case completely, because it caused the department to change their permanency plan from family reunification to relative adoption. And that was incredibly scary. And it was the moment where I think that she realized that this wasn't, and I don't think she ever thought this wasn't a real thing or it wasn't something to be concerned about. But I think for the first time really was in the sights of this could actually happen and her parental rights could actually be terminated. And it was, again, a flood of emotion on her part, rightfully so. It was a really, really scary time. And it was a situation where I couldn't tell her that it was going to be okay and that I would make it okay, because despite all of my great skills, I am not a wizard and I cannot make facts be a way that they're not. And so it really was Kameryn having to do the work about dusting herself off, about doing the treatment, about doing the therapy, about addressing the trauma, about taking a look at herself and her past and her family circumstance and really truly wanting it to be different for her child and putting the work in to get there. And it was not easy. And so I give her credit from the beginning to the end, because she is the one that it was her blood, sweat, and tears that got her daughter home. It really was. And so I can't stress that enough, is that, despite all the skills that an attorney might have, at the end of the day, it is a parent that has to do the work. We can guide them through it. We can navigate them there, but they're the ones that have to make it happen. And Kameryn really did. And she's a shining example of that where you start does not have to be where you end. And that is really truly what her circumstances were. I have to brag on her because she has done a remarkable job post CPS case of establishing a really beautiful family and working and being an incredibly productive member of society and being a good friend and a good partner and a great mom. And she did that. She did it.
5 years sober, 5 years clean, 5 years back with my kid. Hey, I was homeless 5 years ago.
Wow.
So
what a great story for everybody to be privy to here today for both of you. We have a little bit more time left. I just have a couple more questions. Janet was talking about navigating your client through these, dangerous waters. Cindy, what do you challenge in a case, and how do you feel it? Do you feel as if the department is in charge of everything, or do you feel that you have to show your client, look, you're a party to this case and you have just as much right to try and navigate things as they do? How do you see that?
Sure. I definitely don't subscribe to I'm just along for the ride of whatever the department says. And I think that is really frustrating to watch that happen in courtrooms across the state. For attorneys representing parents. We're an independent party. We have independent rights. Our clients do. And so the way I do it and the way I view a case is I'm always going to have my own plan with my client. The department, as the petitioner, is going to have their primary and concurrent plans and how they're going to operate on that case. And then my client and I are going to have our own plans for what we want to be doing on the case and proactively litigating those. I firmly believe that 4 months in between docket or statutory hearings hearings is too long for many of the issues on the case, especially in the middle of it. And so I think a couple different things I challenge. I think Janet already addressed some of those, family plans of service, visitation plans, and placement. Those are all proactive motions I would be filing if necessary, in addition to monitored returns as we get closer, if we can't reach agreement on that. And to all of those, if we have a good case and the facts are good, then I am going to be taking that to court and letting a judge decide if I'm in opposition to the department. And I think that holds through of having my own concurrent plan all the way until trial. And that includes litigating the case, right? Filing an answer and counter petition so that I have claims at trial besides termination. That includes discovery requests. That includes making sure that I'm up to date on everything going on in the case so that we can build our own separate case if things do not turn out in my client's favor.
Excellent. Well, we've got 3 minutes left. And in that last few minutes, I'd like to ask the parents, Jacqueline, is there anything that you wish your attorney would have done differently or that you wish would have happened differently with your case?
Was Miss Cindy? Absolutely not. I am eternally grateful for her advocacy, and her advocacy is what I had envisioned from the beginning of my case. My first court-appointed attorney, I felt called it in, and it's disappointing because of my concern of that person still being active in the Bexar County system, and to know what I didn't get out of the individual. That was my biggest concern, is that nobody should have to, hopefully nobody finds himself in this situation, but nobody should have to go in thinking that they're alone simply because they received an court-appointed lawyer. Like I've seen situations where people go into debt to try to get a lawyer who doesn't do anything. Court-appointed lawyers do amazing. I'm just, if everybody was Miss Cindy and Miss Janet, Texas would be a better place. That's all I can think of.
That's a wonderful sentiment. Kameryn, what about you? Anything you wish would have gone differently in your case?
I honestly wish I probably would have listened earlier on, a little bit earlier. Probably just listened to Janet and took her advice. As Janet said before, I was my biggest critic, my biggest downfall in my case, but having Janet in my corner, it helped so much. It helped so much with my case, even my personal legal proceedings. Janet helped me there too. I mean, wow. But nothing, I wouldn't change nothing that she does. And whoever gets her as a lawyer is extremely blessed.
Well, Janet and Cindy, I can't think of better testaments to your representation. And if a client's ever upset about who their representation is, they can always bring that attention to the court. They always have the opportunity to bring that up to the court. But we're out of time. So on behalf of the Children's Commission, I want to thank the panelists for joining us today. Jacqueline and Kameryn, thank you for your willingness to share your experience in your life with us. And I hope that we all hope the audience is able to take away one thing that you can incorporate into your practice that would ensure better outcomes for the families involved in the child welfare system. Renee, I'm going to give it back to you to provide the MCLE information on the commission website.
Thank you again to you, Judge Falkenberg, and to our panelists, Jacqueline, Reyna, Kameryn Townsend, Cynthia Dyar, and Janet Vanderzanden, for your willingness to talk about this important topic with us today. If you have questions for our panelists, please send an email to cctraining@txcourts.gov, and we will get them out to our panelists for response. A recording of this webcast will be made available on the Children's Commission's website, and individuals who watch the replay may contact cctraining@txcourts.gov for MCLE self-report information.